Good evening, friends. Once again, welcome to each one of you in this uh, refresher course on Company Jack. Today's third session, as one is missed due to cancelled due to some situation. Today's topic is handling of MCA notices relating to non-compliances under Company Jack, compounding and adjudication. And we have with us our eminent expert, CS Santosh Pandey. Sir, welcome to you. And before starting the today's topic, I would like to brief about him. He is presently an ARC North India Regional Council member of ICSI and having a vast experience in the field of Companies Act, having a practice firm named Santosh Pandey and Associate at New Delhi. He has delivered many lectures in the various platforms with NIRC of ICI, MCA, study circles, and everywhere at the branches and chapters also. He believed that knowledge shared is knowledge scared, and one can learn from the others, benefit from their experience. So we would like to welcome on this platform Santosh, as recording is available, so some participant might not be joined. So welcome to you for this session. And I request to you to deliver your technical session.
Thank you so much, Sumitji, for introducing me. And at the outset, I would like to thank CSA, Sumitji, and Ashaji for giving me this opportunity to address you people on a very different and apt topic, which is handling of MCA show cause notices. So why this? I will directly jump to the presentation. Prior to that, I would like to tell you why this topic is necessary. It's just because in the recent past, what has been observed that firstly there has been a shift from the penal provision of the Companies Act, and that shift is you might have seen the change that penal provision is having the change of wording of punishable with fine to liable to penalty. So we need to understand the difference between that, and that's why there is a subheading which is there in to the main heading of the today's presentation, that is compounding and adjudication, because you won't be able to handle the MCA show cause notices unless you are not aware of compounding and adjudication. So I will be touching on the provisions on compounding and adjudication, and then after I will be telling you the thought process you should carry while making reply to Ministry of Corporate Affairs show cause notices. Also, second thought which came in my mind while deciding this topic is that recently what has happened that Central Scrutiny Center has been launched by MCA. It is in pipeline or might be working. Quota House of Quota House Department of MCA has also became active, and they have issued notice under various provisions for the non-compliances. And what I saw that professionals are not having maybe my whatever case has come in front of me, what I've seen that the professionals have not placed the facts correctly while replying to the MCA notices, and at the later stage it becomes very grave. Why so? Because once you file the reply in writing in black and white, later on changing or deviating from that fact which you have mentioned in the reply is little difficult. Also, sometimes suppose you are agreed by the order of any court, or you can say adjudicating authority, the appealing right also get restricted. So that's why the first step to file the reply to the show cause notice is very important thing to be kept in mind. The points to be mentioned, the facts to be provided, the interpretation to be provided. So in this presentation I will be touching all those thought process which I carry while replying to such notices. And I would like to share my presentation now. Okay, so prior to starting the presentation, just a small disclaimer that whatever views I'm giving here are strictly mine, and interpretation is something which is uncertain. Your interpretation may be different. So I want you to tell your answers in the chat box. I have framed certain questions in my presentation so that this session can be interactive, because we are on online mode. So I'm not able to see faces of all of you. So it's something like I'm talking to myself. And it would be great if you can also switch on your camera so that I can also feel interactive. And otherwise, you may give your answer in yes or no in the chat box. Okay, so I will be reading those answers, and it will be great to have your views, because I am not only here to give input to or addition, value addition to you. Rather, I also want to have some value addition from your side. Okay, so in my presentation, what I will be covering is the purpose of the company law committee. What happened is that that company law committee in the year 2018-19 was formed, and that was given a specific purpose. So what is the purpose of that? I will let you know. I will make you understand certain terminologies, which includes fine, penalty, and offense, default. And I will be just one more thing you have to keep in mind while whole presentation, that whatever I am explaining is just from the perspective of Companies Act. Don't confuse it with other acts, because other acts may have different meaning. Kailashji, I would request you to kindly mute yourself. Kailashji, I would request you to kindly mute yourself, please. Sumit, can you help me out by muting this Kailash person with the name Kailash? Sumit,
Hello.
yeah, Sumit, can you help me out by muting Kailash?
लॉक कर रहा हूँ सबको ना, अदरवाइज अनम्यूट होता रहेगा.
नहीं दैट्स फाइन, वो म्यूट अनम्यूट रहने दीजिएगा, क्योंकि वो लोग वरना अपना आंसर नहीं बता पाएंगे मेरे को.
ओके
So
ओके
it won't be interactive. I want to have it.
हाँ ठीक है, मैंने अलाउ किया हुआ है. एवरीवन कैन अनम्यूट.
हाँ, कैलाश को आप प्लीज म्यूट कर दीजिएगा, ठीक है ना? ओके.
यस सर, सारे अलाउड है, अनम्यूट कर सकते हैं अपने आप को.
Okay, got it. So now moving forward, so whatever I will be explaining, the meaning of fine, penalty, offense, default, it is just from the perspective of Companies Act. Don't make it confused with other acts, because other acts may have different meaning of that. So third thing I will be touching upon, then I will be coming to compounding of offenses, section 441. I will be sharing one interesting judgment with you, which is relevant for the understanding the provisions of 441 in depth. Then after I will move to adjudication of penalties. Then after I will let you know the comparison between compounding and adjudication, because today also many professionals are confused that when the compounding application has to be moved and when the adjudication process will be started. Then after, at the end, I will be telling you the thought process you should carry for replying to the MCA notices, show cause notices. So first thing, the purpose of the Company Law Committee 2018 and 19 was divided in 3 to 4 5 parts. First part was the declogging of the courts. What used to happen earlier is that NCLT 80 is a summary trial court, and it was constituted with an intent that all the company law serious matters will be taken care by NCLT and 80. But what was observed that in spite of having the focus on the serious matters like operation mismanagement, merger amalgamation, and corporate restructuring matters, IVC matters, share transfer dispute matters, major of the matters were coming up for compounding of offenses, and that too offenses of procedural non-compliances. What do you mean by procedural non-compliances? Suppose Mr. Ranga Swamiji, who is there as a participant, has been appointed as a director in a company, and company has passed the board resolution or the ordinary resolution, whatsoever as the case may be, but company has not filed DRTL. So what used to earlier happen is they used to prosecute, then after the company used to go to the court for the compounding of offenses, and it was getting difficult for the honorable tribunal and appellate tribunal to look after the serious cases of O&M, corporate restructuring, etc. So with this purpose, declogging of court, in which the thought process came up that for the non-procedural compliances, the mechanism should another mechanism should be there, which should be adjudication mechanism, and that should be shifted from the compounding aspect to the adjudication aspect. So in this way, the declogging of the code and code will be unburdened with the cases of procedural non-compliances. That was the first intent. Second was that ease of doing business. Now earlier, suppose just giving an example, it's not I'm not saying that I have personally observed that, but I'm just giving an example. Again, the same thing. Ranga Swamiji is the director of the company and he has been appointed, and but his DRTL has not been filed for 8 to 10 months, suppose, and meanwhile this prosecution gets started. So suppose Ranga Swamiji has to go outside India for some business transaction on behalf of the company, but while applying the visa, he has to give an affidavit or declaration that there is no prosecution pending against him, right? But he cannot give so because already MCA has started the prosecution against him. And why the prosecution was there? It's just because of the procedural non-compliance. And what it was affecting is the ease of doing business, ease of living of corporates, and that's why similarly, a lot of prosecution was happening against the company, due to which the company was already always in the radar of the serious non-compliances rather than the little bit non-compliances. So for the ease of living of corporates and ease of doing business, this concept was evolved that to form a company law committee, and also that procedural non-compliances cases should be speedily disposed of. That was the intent, and that's why in-house adjudication mechanism was introduced. I will let you know in detail what is in-house adjudication mechanism. And the shift of penal provision from punishable with fine to liable to penalty is a shift of criminal nature to civil wrong. Now, from the Companies Act perspective, wherever penal provision is carrying punishable with fine, it's a criminal nature. And wherever the penal provision is carrying liable to penalty, it's a civil nature from the Companies Act perspective. Only from the Companies Act perspective. Again, I am saying. Am I clear till now? Please keep saying your views. Am I clear till now? Okay. Okay. So now coming to fine and penalty, the difference between fine and penalty. Now, fine, the rule of interpretation says that you have to first refer to the definition provided under the Companies Act, and then after you have to refer to the General Clause Act, and then after, if General Clause Act is also not explaining the word or term, then you have to go for the ordinary dictionary meaning or any specific law dictionary meaning. So meaning of fine has not been defined under Companies Act, and also it is not provided under the General Clause Act. So I prefer certain dictionaries for understanding the meaning of things. So as per Dictionary of Black Law, Oxford reference, it says that a sum of money that an offender, now offender is a very grave word here, offender is ordered to pay on conviction by the court. So it means there is a engagement of the court for ascertaining that someone is an offender, and also for imposing some of money on him to be paid. Okay, so as per Black Law Dictionary, a sum of money paid at the end to make an end of a transaction short of prosecution. It means if I see overall meaning, it says that there should be an engagement of court, there should be a proper trial, person should be an offender, then after a sum of money will be imposed on him, and then he has to pay it. So there is a proper trial. Okay, but if I will come for penalty, penalty is simple sense a punishment imposed for breaking a law, rule, or contract. Like for example, suppose you are driving a car, okay, and you jump the red light, okay, and policeman scolds you and asks you to pay the challan. Now you are having two options: either you pay the challan then and there, adjudicate the matter, or you will say that no sir, I am sure that at that the time I jumped the light, it was a yellow light, it was not red light, so I want to challenge your ground. So what he will ask you is to give the paper of the vehicle and come to the court. That will be the statement of the policeman. So what was happening in that case is you have not opted for the adjudication, rather you have opted for the prosecution. So that is the difference between fine and penalty. Okay, am I clear? Am I clear?
Yes.
Okay, thank you, Sanjeev ji. Thank you, Sanjeev. Okay, now moving forward. So in simple sense, in fine, it will be a proper prosecution, proper trial, complaint will be lodged, reply will be filed, written statement will be taken up, witness will be done before the appropriate court whatsoever. In penalty, there will not be any requirement of proper trial. Simple notice will be given to you, and a reasonable opportunity of being heard will be given to you. You have to file the reply. If they are satisfied, then fine. Otherwise, not. Like in the case of the traffic challan, you keep on saying, and they ask you to pay challan then and there. So they do not get satisfied. I haven't seen policemen getting satisfied legally. I would like to add word legally at the end. So same way, this ROC adjudication goes up, that they will issue the notice, you have to file the reply, adjudication will happen. If they are satisfied, that's fine. If they are unsatisfied, they will impose the penalty. Now, meaning of default and offense. Again, default has not been defined under Companies Act. Again, not in General Clause Act. So we have to refer to the Black Law Dictionary. So it says that a failure, an omission of that which ought to be done. Like for example, Ranga Swamiji was appointed as a director and his DITL was not filed. So it's just an omission. It is not impacting the appointment of the director Ranga Swamiji, right? So this is just a mere minor default. It's not a grave offense. So that is the meaning of default provided under the Black Law Dictionary. Now, meaning of offense surprisingly has been provided under General Clause Act, which says that offense shall mean any act made punishable by any law. Now, I have deleted two words from this definition. Why so? Because otherwise there will be confusion amongst yourself. The real definition is offense shall mean any act or omission, because otherwise omission you will link to default. So that's why I deleted deliberately that thing. So for your for your knowledge, offense shall mean, from the Companies Act perspective, offense shall mean any act made punishable by any law. Punishable now again is a very grave word. Punishable means a person is able to be punished, and who will decide the punishment? The court, right? So court will be deciding the punishment and proper trial again will be happening. So that is the meaning of offense. Now, as per Black Law Dictionary, which is, supplementing the view which I have shared just now, it says that a crime or misdemeanor or a breach of the criminal law. So it is, somewhere Black Law Dictionary is, based on various case laws, and it is giving that meaning to offense that a crime. So it means it is linked to the criminal activity. So it is a note which I have made for myself, that it might be the possibility that default may not be that much grave which can lead to any offense, but every offense will be having some ingredient of default in it. So offense is a broader word, and default is just restricted to the minor mistakes. Now, difference between criminal wrong and civil wrong. Now, in criminal wrong, public at large is getting affected, or society is harmed. Like for example, now it is like for example, suppose someone has been murdered in your locality. It is not that only the family members is going to file the case. So it is public at large which is getting affected. So it is always the state which is filing the case, or against the state which is the case getting filed. In civil wrong, the public at large does not get affected. Suppose me and Ranga Swamiji has entered into a transaction wherein Ranga Swamiji has given me 10 lakh rupees, and I have not paid him within a due time. So this is a dispute between me and Ranga Swamiji, and Ranga Swamiji has to file the recovery suit against me. So this is just like he can do it in single capacity. Sanjeev ji is not having any concern whether Ranga Swamiji is getting money or not. Okay, so that is the difference between criminal wrong and civil wrong. In criminal wrong, proper prosecution, I have already explained that proper prosecution or trial will happen. In civil wrong, normal proceeding before the concerned authority will happen. Criminal wrong is grave, civil wrong is technical or minor wrongs. And I have already explained that state takes action in criminal wrong, civil wrong, aggrieved person takes the action. And in criminal wrong, court imposes the fine or imprisonment. And in civil wrong, appropriate authority whatsoever is the adjudicating authority, ROC, RD, etc., will be imposing monetary punishment on you. In criminal wrong, there should be, the presence of mens rea, and in civil wrong, there is no requirement of mens rea. Now, for explaining the what is mens rea is the guilty intention. For explaining the clear meaning of this difference, this is the best time. Let's suppose MCA V3 portal is not working, right? We all know that there is a lot of technical glitch going on. So during this period, suppose earlier was the regime in which the section 42 was not having the liable to penalty provision, and it was punishable with fine. And at that time, V3 was launched and V3 was having the issue. So what section 42 says that you cannot use the funds raised until or unless the allotment has been done and PAS 3 has been filed. But PAS 3 is not getting filed due to V3. Now our intention is clear that I want to file PAS 3. I tried several times. There is a lot of technical glitch which is happening, due to which I'm not able to file. But at the same time, it is affecting my operations because I'm not able to use the funds. So that can be an example that suppose you start using funds prior to filing the PS3 and the penal provision is having punishable with fine. I'm talking about the earlier regime. So punishable with fine. So in that case, you can argue before court. Suppose tomorrow ROC comes up with the prosecution that yes, Mr. Santosh Pandey, director of the company, has done some offense. He has used the fund prior to the allotment and PAS 3 filing. So I can take the ground along with the screenshot evidences that see, I was having the intent to file the PAS 3 form. I was not able to do so just because of the fault at the part of the MCA, and I was not having any intention to harm or breach the law which you have given to me, right? So presence of mens rea is the first thing which has to be checked in criminal cases. So I will not go in deep in that. Otherwise, we will keep on discussing this thing. This is a very, very debatable topic. It depends upon the facts also sometimes. So I won't go deep in that. In simple sense, as I started with the say that punishable with fine offenses is a criminal thing, and liable to penalty default is a civil wrong from the perspective of companies that again I'm saying. Okay. Now coming to compounding of offenses. Again, compounding has not been defined under Companies Act. Okay. So we have to refer to the General Clause Act. General Clause Act also does not provide the definition of compounding. So you will refer to Black Law Dictionary. What does Black Law Dictionary says? Static settlement or the compromise. Suppose tomorrow, suppose tonight, a thief comes up, barge into my home, and I caught him. And the time I caught him, he says me that prior to stealing things at your home, I went to the Ambani's home, and there's a lot of gold with me. I don't want to, I don't want you to, hand over me to the police. I want you to keep this gold which I have taken, which I have stolen from Ambani's home. So that is a sort of compromise I am doing with the, that thief. And that thief, that I am just settling that I will not be taking him to the police station. So that is a sort of settlement. So that is where a compounding meaning has been provided under Black Law Dictionary. That is a felony. Felony is the word for crime which is used in US. It says that the offense committed by a person and who has been directly injured, yani ki me, by a felony agrees with the criminal that he will not prosecute him. So in the similar manner, in under companies that suppose I am the director of the company, so I get to know that some non-compliance has happened, and there is a penal provision of punishment with fine, and I know that tomorrow or after 6 months ROC is going to prosecute me for that. I assume to go to ROC that such non-compliance has happened by me, and that was not an intentional one. I want to compound that thing. I want to settle that thing because I do not want to have that glitch in my mind that tomorrow you are going to come up with the prosecution. I do not want to face the prosecution. I do not want to waste my time and cost onto that. So I want to have this settlement. So that is the meaning of compromise, compounding. That is called compromise. Okay, so now there are certain changes in 441. Earlier, what was the provision is that only under Companies Act 1956, the fine or imprisonment or both or even fine only can be compounded. But surprisingly, in Companies Act 2013, only the the section 4441, which is dealing with compounding, was having the word that only fine, penal provision having only fine can be compounded. And if the penal provision is fine or imprisonment, that means where the imprisonment is not mandatory, then also the compounding is not possible. Okay. So second change was that 441 subsection 6 said earlier, it was saying that for compounding the offenses which is having optional imprisonment, the permission of the special court is required. So now that change has been brought in, that you do not require a special court permission. Now the scenario is that any offense which is punishable with fine only, fine or imprisonment, or fine or imprisonment, or both. It means wherever there is a fine only or imprisonment is not mandatory, it's optional, so that can be compounded. Okay, so that is the change. And now second change is with respect to sorry, so I have already explained this thing. If there is a mandatory imprisonment, the compounding is not possible. Now second thing is second change is respect to the 441 subsection 1b, wherein earlier the limit was 5 lakh for the a threshold limit was provided of 5 lakh for the regional director to compound the offense. It means the regional director cannot compound the offense wherein the fine is above 5 lakh. If it is below 5 lakh, then only he can compound. Now it has been increased to 25 lakh. Now RD can compound the offenses wherein the fine involved is up to 25 lakh. So that is the second change. Okay, now this is the language of 441 subsection 1. Would you people like to interpret the language? Because otherwise, because this is the way I follow this presentation generally. So would you be happy to interpret, or I should go with my interpretation? Yes, please tell me. Please tell me. Please go ahead. Okay, thank you, Pooja. So if I will read 441, it is starting with a non-obstant clause, which is overriding Code of Criminal Procedure, and it is saying that notwithstanding anything contained in the Code of Criminal Procedure, it means suppose something contrary is there in CRPC, that will not be overriding my Companies Act, and any offense under this act, whether committed by a company or its officer, not being an offense punishable with imprisonment or one second, or only, or punishable with imprisonment and also with fine. It means a mandatory imprisonment there. So may either before or after the institution of the prosecution. It means either the prosecution has been launched or not launched. Okay, then if the prosecution is pending also, then you can go for compounding, and the compounding can be done by the tribunal, or where the maximum amount of fine is up to 25 lakh by the regional director. Now there is two school of thoughts. First is that tribunal cannot compound offenses below 25 lakh. And second is that tribunal can compound any offenses of any limit of fine. Because 441 subsection 1 clause A, the tribunal word which has been given, it is not having any threshold. There is no restriction on the tribunal, and tribunal is a higher authority in comparison to the RD. So RD is having the restriction, but not the tribunal. So that is the first school of thought. It means that ROC can, forward the case of compounding to tribunal also, to regional director also, as per his wish. Okay. Second school of thought is, then what is the use of RD's power? Why RD has been specifically given the power of 25 lakh? So, in my view, okay, in my view, tribunal can compound offense of any amount, involving any amount of fine. It may be 1 rupee, it may be 1 crore, whatsoever, the compounding can be done by the tribunal. RD is having the restriction of 25 lakh rupees. So that is the interpretation of mine. But there are certain, surprising things I would like to share with you. So first question, generally I ask questions. If you want to answer it, so you can do that. In this case, what has happened is that company was not able to hold its AGM in due time, and there was a delay of 100 days. And total fine was coming roughly around 10 lakh. Now, who is authorized to compound the offense? As per my interpretation, it is both. What is your interpretation? What is your interpretation? Okay. I have received certain. Okay, Akshay ji is saying both. Both. Okay, so no, after going through your opinion, both. Okay, thank you, Sanjeev. Prior to going my opinion, it was like RD can compound only. Okay, right. Thank you so much. So, do you want me to switch to Hindi? If you want me, I will do that. Yes, Sanjeev ji, can you confirm? Should I shift to Hindi? Okay. No, Pooja ji, you said that should be both as per your interpretation. See, that is my interpretation. I want to have your interpretation also, because otherwise it will not be an interactive session. You may have a contrary view. Maybe I also can change my view later in the presentation. Okay. Okay. Great. Thank you. So now moving forward. Now, to whom the application for compounding has to be made if the estimated fine is 24 lakh and if the estimated fine is 50 lakh? Yes, anyone who can answer me. To whom the application for compounding will be done, will be made? RD, NCLT, or both, or any other authority? What do you say? To whom the application for compounding will be made? $24 lakh tribunal and 50 lakh. 50 lakh RD. I think you have confused yourself. It's below 25 lakh. It's RD. Okay, Sanjeev ji is saying, see, both second tribunal. Okay, right. Pooja ji, I understood that. But again, now you have not noticed the question properly. It is saying to whom the application for compounding has to be made. The settlement is happening with ROC. You have to make an application to ROC. ROC will be forwarding it to the RD or NCLT, whatsoever case. Right? My second question is a little twisting question, which is asking to whom the application will be made. एप्लीकेशन तो आप आरओसी को ही लगाओगे, आरओसी आगे उसको फॉरवर्ड करेगा किसके पास रजिस्टर करना है, केस किसके पास जाना है. Am I clear? Am I clear?
Yes, sir.
Yeah. Thank you, Sangeeta ji. Please, are you saying something?
I was saying yes. Thank you.
Thank you so much, Sangeeta ji. Now 441 subsection 2. It says that nothing in subsection 1 shall apply to an offence committed by a company or its officer within a period of 3 years from the date on which a similar offence committed by it or him was compounded under this section. Yani ki, if suppose today the compounding has been done and if you're committing an offence within 3 years, then the same offence cannot be compounded. Okay. Now explanation, it is saying that if any subsequent offense happens, in the same similar nature offense happens after 3 years, then it will be considered as a fresh case. Okay, so this is the interpretation of 441 subsection 2. Now I want you to answer this question. I want you to answer this question, whether compounding is possible or not. Suppose company has violated 185 for 3 years, 2016, 17, 17, 18, and 18, 19. And they moved the application for compounding of only 2016-17. Got the favorable order of compounding. Now they get to know, they realize that, oh, sorry, for 17, 18, 18, 19 was also the non-compliance year. So whether now they can move for 17, 18, and 18, 19 after the compounding order of 2016-17. And it is the 2023, which we are in. We have moved the application today for 2016-17 and we got the favorable order. Yes. Now whether a company can do so? You can also unmute yourself. मुझे भी अच्छा लगेगा आप लोगों को सुन के. Yes. Please share your views on this question. You need time, that's fine. Okay. Pooja ji is saying yes. Okay, Pooja ji, I would request you to kindly unmute and share your view. Why it is
No,
yes?
sir. No, sir.
No. Okay, Sangeeta ji, I
No.
will come back to you. Let me have the view of Pooja ji first. Pooja ji, I would request you to kindly unmute and share your view. Why you are saying that yes, it is possible.
सर आप पहले संगीता जी से सुन लीजिए फिर मैं बताती हूँ.
अच्छा ठीक है, संगीता जी
Thank you.
प्लीज बताइए.
सर ने बोला कि 3 साल तक सेम ऑफेंस को आप वो नहीं कर सकते कंपाउंड अगेन, अगर एक बार हो गया तो.
ओके.
दैट्स व्हाई
नाउ
आई सेड
पूजा
नो.
आप ओके ठीक है, पूजा आप बताइए. पूजा जी
हाँ जी
आप बता
सर.
सकते हैं आप. हाँ आप बताइए. Why you are saying yes?
सर आई थिंक अगर 1 साल का भी हुआ है तो 2 साल का बाकी अगर करा भी है तो जा सकते हैं. शुड नॉट बी अ वायलेशन अकॉर्डिंग टू मी.
अच्छा ओके.
क्योंकि अगर
So-
उन्होंने मतलब मैं लॉजिकली भी सोच रही हूँ कि अगर उन्होंने 1 ही साल का एप्लीकेशन दिया इट इज ओके. बट क्योंकि 2 साल का वायलेशन हुआ था, व्हेन द एनसीईआरटी और आरडी विल बी सीइंग, तो इट विल सी इन टोटलिटी, यू नो, कि
Right.
उनका कितने गैप है. तो जब वो ऑर्डर देंगे तो दे शुड बी गिविंग फॉर ऑल द पास्ट ऑफेंसेस, आई मीन वॉलेशंस व्हिच हैज बीन डन. तो इट शुड कम. एक ईयर से नहीं आएगा, वो सबका ही आना चाहिए उनको ऑर्डर भी. थैंक यू सर.
Okay. Sanjeev ji is saying that yes, for 17, 18 and 18, 19 can be, as it was not issue of earlier compounding. This is his view. Okay, so Sangeeta ji, I would like to again interpret section 441 subsection 2. What I interpreted is that if a similar offense is getting committed within 3 years. Now in this question, the commission of offense has already happened in 17, 18 and 18, 19. I am moving the compounding application today. So there is no bar on me. Suppose in 2023, I get the compounding done of 2016, 17. And then after in 23, 24, I commit the offense again under section 185. Then the compounding of 23, 24 is not allowed. For 17, 18, 18, 19, it is clearly allowed. For all the offenses committed prior to the compounding, that can be compound. There is no bar on that. Okay, am I clear?
Great. Thank you. Great.
Okay, and second thing now in the similar thing for this particular second question, which says that 2016-17 AGM has happened in 1920, and for the financial year 17-18 and 18-19, the AGM has not happened till now. And without holding the AGM for 17-18, 18-19, now company moves an application for compounding of offense of 2016-17 and get the favorable order. Now post compliance of such order of compounding, they get to know that they have missed to conduct the AGM for 2017 and 18, and now they conduct it. After getting the compounding order, they conduct it today. Now whether compounding application can be moved?
नहीं सर, अब नहीं होना चाहिए क्योंकि उनका जो फर्स्ट एजीएम था वही डिले था.
Okay. Okay. Anyone else? कुछ और view? Any other view? Sanjeev ji, I'm expecting an answer from you. Okay, so see again, Pooja, now here the interpretation has been little on the wrong side from your side, is because though the offense was continuing and it has been made good later after doing the compounding of 2017, but when the offense was committed is due date provided for 2017-18 and 18-19, which was 30th September 2018 and 30th September 2019 respectively. So commission of offenses happened already prior to the application for compounding and compounding order. So here also compounding is possible. What you are doing after getting the compounding order is making the offense good by conducting the AGM. Making the offense good is not covered under 441 subsection 2. The commission you have to check. Okay, thank you, Pooja, for confirming. Now moving forward, 451 is a very interesting provision. It says that if a repeated default has happened within 3 years, then repeated offense has happened within 3 years, then the fine will be doubled, and in addition to any imprisonment. Now, in addition to any imprisonment is a very different language which has been used. Suppose the penal provision is carrying optional imprisonment, it will become mandatory. That is one interpretation. Second interpretation is that we cannot be that harsh while doing so. Otherwise, it will defeat the purpose of the compounding at once. So that is 451. Now, what I will not take these questions. I will directly jump into the case law. Okay, because these questions are similar to the earlier questions. So I will directly jump into the case law. So this is the case of Magnus Solutions Private Limited versus ROC, and in which the Honorable NCLT Delhi Bench Court 3 has rejected cases of compounding at once of club. It was a clubbed order for approximately 70-80 plus companies. And what was the findings of NCLT was that compounding cannot be done by NCLT if the amount of fine is not exceeding 5 lakh. It has to be done by RD. That was the first finding. At that time, the prevailing fine for threshold for RD was 5 lakh. Now it is 25 lakh. Now, second is that repeated default within 3 years cannot be compounded by virtue of section 441 subsection 2, which we were confusing amongst us, that what should be the interpretation. Sangeeta was having different view. Pooja ji was having different view in the questions which I have asked earlier. So that was the view of NCLT, Honorable NCLT, that if the repeated default is there, the same offense cannot be compounded by virtue of section 441 subsection 2. Now, third is there is no provision for combined application. So combined application is not possible. So you have to make the separate application, and once I will compound one application, I cannot compound other two applications. 451 is bringing mandatory imprisonment into picture, and where the mandatory imprisonment will be there, the compounding is not possible. That was the interpretation of Honorable NCLT. The case was then appealed before Honorable NCLAT, and what was the finding? That has totally reversed the finding of the Honorable NCLT. It said that regional director is having the threshold, tribunal is not having the threshold. Second, repeated default in 3 years can be clubbed for compounding in one application, because see, rules at the court are the handmaid of the justice. So at one time you are saying that you are burdened with the non-procedural procedural non-compliance cases, and now today you are saying that you have to move the separate application. You will be dealing with one and one each application separately, though it is of the same company, it is of the same nature offense. So that harm the purpose of the formation of the company law committee, and also at the same time there is no bar in the act for the moving of the combined application. In 1974, there was a Department of Corporate Affairs circular which was saying that yes, combined application can be allowed. So today in companies of 2013 also that view can be taken forward for the combined application. That was the view of Honorable NCLT, and it is not harming the intent of the legislature also. Third, that the offense committed after expiry of period of 3 years. That was the language. So 441 subsection 2 is not anywhere restricting you to compound offenses which has happened prior to the compounding applications at once. So it is not bringing any such restriction. And 451 is also not giving you mandatory imprisonment. You are a summary trial court. You cannot interpret the law in such a manner. You do not have such power. That was the finding of Honorable NCLT. And imprisonment is not possible in case of company anyway. So company can always go for compounding. That was the interpretation, that you can say that was the finding of the Honorable NCLT. Now, again, 441 subsection 1 again, which was saying that there was a threshold on RD but not on tribunal. So who can compound the offense when the fine is only there? Fine only, then tribunal, RD, or any other authority which has been authorized by the central government. If fine or imprisonment is there, so as per my view, that can be compounded by tribunal only, because 441 subsection 1 clause B is authorizing RD to compound offenses where there is only fine, and that too up to 25 lakh. It is not giving power to RD to compound the offense for the fine or imprisonment. Practically, it is happening that RD is compounding offenses which I have seen for the penal provision where there is fine or imprisonment. So as for my understanding, my view, presently my view, it may change in future depending upon the cases which will be coming or the view which will be taken by the superior authorities. So in my view, it is not, RD is not authorized to do so. Again, fine or imprisonment, fine whatsoever is the amount, tribunal can do it only. Fine or imprisonment or both, tribunal can do it only. Fine and imprisonment, compounding is not possible under Companies Act. Imprisonment only, compounding is not possible under Companies Act. So for the last two cases where you will compound is CRPC. Suppose a client is, had committed some offense which is having mandatory imprisonment under the Companies Act, the compounding is possible in CRPC, not under Companies Act, but in CRPC. So you can advise your client that way. So where to move an application? I have already discussed that you have to move an application to ROC. 4441 subsection 3A itself says that every application for compounding of offense shall be made to the registrar. Rule 88 of NCLT rule says that any reference to the tribunal by the registrar of companies. Okay, so it means that reference has to be given to the tribunal by the ROC, not by you. I have seen professionals are drafting compounding application with the title that before the National Company Law Tribunal, before the regional director. That is not the correct step to be followed. Okay, so you have to make reference to only ROC. ROC will be making further reference to the tribunal or RD, whatever is the case. Whether compounding application can be rejected at what circumstances, I have already discussed the circumstances. If it is having the mandatory imprisonment, if it is having investigation pending, if it is having that similar offense has been compounded, so compounding application can be rejected. Whether compounding is possible if investigation is pending, it is not. 441 clearly says that investigation if pending under Companies Act 2013. Again, investigation under Companies Act 2013. If it is pending under any other law, suppose SEBI, suppose FEMA, or any other law, then there is no bar for compounding under Companies Act. Only the offense investigation pending under Companies Act. If it is pending under Companies Act, then only compounding is not possible. Otherwise, it is possible. Whether compounding order passed by RD or NCLT can be challenged, where to challenge. So, as for my understanding, that compounding order passed by RD or NCLT can be challenged definitely, but whenever you are now you do not you have got a favorable order. So sometimes the question comes up that you have got a favorable order of compounding, then why you are challenging it further. So it might be the possibility that the compounding fees which has been imposed by the RD or honorable NCLT, that is on the higher side. Okay, so you can appeal against that particular part of compounding fee before the superior authority. So but in that case, you have to be very particular while making the argument before the authority, whatsoever RD or NCLT, that please, my lords, that I would request you to kindly note down my statement that I want to challenge this particular part of compounding fee which you are imposing on me. I am happy with the rest of the order, but not with the compounding fee. So I would request you to kindly note down my statement. Otherwise, tomorrow when I will file the appeal, if this has not been written in the order passed by you, that will be that will be restricting my right to appeal or uh, affect my appeal in a very grave manner. So I would request you to kindly do that. You have to get it in writing. That will be adding your adding strength to your case. So that is the point. Now, surprisingly, where to challenge for NCLT is NCLT 421 already provides. 421 of the Companies Act 2013 already provides that against the order of NCLT, you can go to NCLT, but the law is silent for RD. Now, for RD, generally a writ is filed before the High Court that RD has passed the order in an arbitrary manner. But there was a case of MC Dotech Services Private Limited versus ROC. That was a surprising case in NCLT Chennai bench, wherein the NCLT Chennai bench passed the order in case of the company who has applied for extension of agent to the ROC, and that extension of agent was not granted by ROC, and the application was rejected. The company moved against the ROC order and appealed before Honorable NCLT Chennai bench. Now NCLT Chennai bench has taken the view and directed the ROC to give the extension, and that was really shocking, because there is no enabling provision in section 96 that if the person is agreed by the order rejection of the ROC for the extension of AGM application, he can go to NCLT. There is no enabling provision, but I believe that Honorable NCLT Chennai bench had used power of Rule 11 of NCLT rules, which is an inherent power. So, but again, as per my view, this is challengeable and debatable thing. So you may refer the cases of RD to NCLT also, having reference to this case. But I'm not sure whether you will win or lose. But definitely a great learning will be there. And in case you will win that case or have a favorable order before NCLT in your case, this is going to be a good branding of yours and the profession. So that is really great. This case law, when compounding is not possible, I have already discussed several times. Now, making of offense good, there are two sort of offenses. One is one-time default. Second is continuing offense. One-time default is secretarial audit. Continuing offense is AGM, जिसमें per day fine होता है. So, making of offense good in one-time offense is not required. You can say that in the subsequent years we have made the offense good. But for continuing offense, you have to make the offense good first, like conducting the AGM first, then only you can move for application. Okay. Now, sorry, this slide has been wrongly mentioned here, 460. I will not take that because I am restricted to compounding and adjudication today. Now, adjudication in simple sense means the process by which the authority imposes the penalty on you after examining your information, any the documents which you have filed with them. They will examine your information, the documents, and then they will give you the opportunity of being heard. And then if they are not satisfied, they will impose the penalty. So that is the meaning of adjudication. Now, what show cause notice must contain? First is the nature of the non-compliances or default under the Act. What has been the nature? Second is the relevant penal provision. If the penal provision is missing, that show cause notice is challengeable. Third thing, that maximum penalty which may be imposed by the on the company or the officer by the authority, that has to be particularly mentioned by them, that what is their maximum power. And fourth is the reasonable opportunity of being heard should be provided, and the time limit should be given in the show cause notice. If any of this thing is missing, then you can challenge that particular thing, that the show cause notice is not proper in terms of law. So you can challenge that thing tomorrow. If ROC takes the view that no, law is very clear, that suppose ROC missed the time period to be given in the show cause notice for the reply, and you challenge that thing, that your show cause notice is not in terms to the adherence to the law, and ROC takes the ground that there is a clear clear provision that it is saying that minimum 15 days is their maximum 30, you take 30 days. So you can challenge that thing, and you can quash the adjudication at the starting itself, show cause notice. So this is the language of show cause notice, which was issued by MCA CMS, that was compliance monitoring system, which was saying that whereas the company is also directed to serve a copy of the said notice to the director of KMP, and this notice will be treated as deemed to have been served to the officer in default in terms of section 20. Now they are taking the shade of section 20 of the Companies Act. Not taking the shade of section 20 generally is not barred. Okay, that's why section 20 has been introduced under Companies Act 2013. But at the same time, suppose you have incorporated a company, okay, and you have put in your mail ID in the master data. We generally, I have seen that professionals keeps their mail ID in the master data, and you get the notice, and you forgot to intimate the directors in the company. Now, just because of your negligence, the company is going to suffer, or the director or the KMP is going to suffer. Similar manner, suppose the management dispute is there in the company, then also suppose I am the director, Sanjeev ji is the director, another director, and there's a dispute. Now I got the notice, I will say that okay, I will handle this case, let Sanjeev be unaware of this particular notice, let him get penalized. So tomorrow Sanjeev ji may be agreed by this particular act of mine. So this is going to harm the intent of reasonable opportunity of being heard, and therefore there are two case laws which I have researched, that Rasiklal versus CWT and Union of India versus Colonel Jain, wherein the finding of the Honorable Supreme Court was that the reasonable opportunity of being heard should be provided in spirit to the law, and mere compliance of such thing will not satisfy. And also that rule of natural justice is there to supplement the law rather than supplanting the law. If this language will be used by the department, while issuing notice to the company, it says that it clearly shows that it is going to be a mere compliance, which has been done by the department. So that is, in my view, is challengeable. Till now, no one has challenged that thing, but in my view, it is challengeable. So points to be considered while they will be passing any order of penalty, and they have been unsatisfied with your reply. First, they will see the size of the company. How much big is your company? If you're a startup company, they may go for that. They will levy less penalty. If you are MSME, they will levy less penalty. If you're a small company, they will levy less penalty. If you are a big company, they may levy high penalty. Yeah, Ajay Gupta ji, are you saying something? Yes, please.
Hello, Santosh ji.
Yeah,
Yeah,
ha,
good
Ajay ji,
evening.
please. Good evening. Good evening.
I have few questions regarding this show cause notice, which we discussed in previous slide. If you can just go to the previous slide.
Yeah, please.
Here I have two, three questions that if in case the email ID is given of the professional and he forwards or miss anyhow to forward the notice to the company or the KMP or the directors or all. So can he be a party of the proceedings in that case?
No, he cannot be, because
Because notice was,
he cannot be.
you can say
He cannot be. Adjudication penalty cannot be imposed against the professional. But honestly, in this case, what will happen is tomorrow company may file a separate case against the professional, and it will be a burden on the company to prove that it was not the mail ID of them, because that was their master data. And they are generally, what is legally happening is that the form is getting prepared by the company. Practically what is happening, that is something separate. So they can reply, but I don't think so department is going to get convinced with that.
okay. Another thing is, in case say department issues a show cause notice to company as well as to KMPs or to the directors, but notice only company receives that show cause. KMP or director somehow miss it, either through any ways in email not received by them, or they physically they not get the notice. So in that case also, can department take action against directors, or it will take
Yes,
action against
see,
company only?
first of all, department is in electronic mode. What is department doing is they are issuing the notice to the company at the designated mail ID provided in the master data. And it is, they are presuming that company will be having the responsibility to give that notice to the director and KMP. Suppose they are sending physical notice, okay, they are sending physical notice, and they have sent it to all the company and all the directors and the KMP, but somehow KMP has not got that notice. And at the later stage, when he got the he has been imposed with the penalty, he got the order, and so he may appeal before the honorable RD that any such notice show cause notice has not been received by me. Even if it has been received by the director, that has not been informed to me. So that onus to prove the thing will be on the KMP, who is saying that he has not been received with the notice. Am I clear?
Yeah, thank you. Please
Thank you so
continue.
much. Okay, perfect. So now moving further, I have already discussed. Second is the nature of business. Nature of business is, suppose the best example is of Corona period. Your company is a manufacturing company, and during Corona period, there has been a lot of damage to the operations of the manufacturing units. So they will see the nature of the business which you are carrying. Suppose you are a pharmaceutical manufacturing, then again the nature has been really fruitful for you during the Corona period. So that may be a point which the department will consider. That has to be the point, rather, not be, maybe will be a wrong word. That has to be the point which they will be considering before imposing the penalty. In injury to the public interest, suppose that adjudication which is going to set aside the non-compliance which you have done by payment of the penalty. So how much injury it is going to bring to the public interest, nature of default, whether it is a one-time default or the repeated default, they will be checking. how much disproportionate gain or unfair advantage you have taken from that particular non-compliance, how much loss you have given to the investor group. So these are, some points which has been provided in the rules, and I can say that apart from these points also, they can consider other points. You can give points in your reply if you are having any other ground to that. Okay. Now rule 3 subrule 212 says that if they cannot impose penalty less than the minimum prescribed. So as for my view, though law is very clear, plain reading has to be given to the provision. You cannot go below the minimum prescribed, but at the same time, there is a case of rooftop industries wherein the SAT has allowed to impose the fine below the minimum prescribed under the SEBI Act, but that is not a case under Companies Act, so I cannot quote here. So I would request you to kindly research on that. As from my understanding, yes, it is possible, because once you are allowing yourself that yes, adjudication you can be satisfied with the reply also, in any way you are going to set aside the show cause notice. So anyway, you are going to not impose any fine, that is 0. So you can be below the minimum. So RD can also modify the order. So that is my ground, that yes, it can be below the minimum, but there is no such order yet passed my knowledge. Rule 3 subrule 13 says that if the fixed penalty is there, that will be fixed, and there will not be any deviation, and the adjudicating authority has to impose that sum. Okay, now process of adjudication, I will be quickly taking it. Issue of show cause notice, minimum 15 days will be given, maximum 30, and reply has to be given online. अगर online आता है तो online, अभी आजकल physical आ जाता है, कई बार तो physical भी करना है, online बट भूल जाइएगा. Now always seek oral representation. Why I am saying it? Suppose you do not seek oral representation, so it is not mandatory on the department to call you for personal hearing. That is a wish of the department to call you for personal hearing. If you will mention specifically that you want to seek oral representation in case your reply is not satisfied, that will become mandatory for the department to call you for personal hearing. So after that, suppose your reply and personal hearing, you are not satisfied. If they are satisfied, that's fine. If they are not satisfied, they will may fix the date of hearing if you have not specifically asked for it. And then after the representation, the order will be passed. And that order, if you're not satisfied, you can challenge it within 16 days. And that order must be duly dated and signed, and must particular reason state the reason for physical appearance. Suppose you have not asked for it and they have called you for physical appearance. So, to cover, or you can say to have a vigilant approach over the corruption thing should not happen. This provision has been introduced, that there should be a particular reason behind calling you for physical appearance in case you have not sorted for that. So in 90 days you have to comply for the order, or within 60 days you have to appeal to the order. Appeal to RD for the against the order, and RD may be confirming, modifying, or setting aside your ROC's order in case he is satisfied with your approach. Now quickly, adjudication and compounding, it will always be civil wrong. Adjudication, as I have already told you, under Companies Act, it is civil wrong. In Companies Act, compounding will be only of criminal nature. The compounding will always of the offences of the criminal nature, that is punishable with fine. And subsequent adjudication is possible. Suppose the same default has happened within 3 years, that is also can also be adjudicated. But same offense, if committed within 3 years after the compounding order, that cannot be compounded. In adjudication, the penal provision is liable to penalty. In compounding, it is punishable with fine. In adjudication, they will levy penalty. In compounding, they will levy compounding fee. Adjudication, there is no provision of suo motu application which can be moved by the company. It will always be started by the authority. But practically, I have seen that company is moving suo motu application in physical form to the ROC that I want to adjudicate this matter, and ROC is taking those cases, because why ROC will be saying no when he is getting money in terms of penalty, right? So in compounding also, suo motu compounding will always be suo motu. That cannot be started by the authority. And adjudication, again, this is a similarity you can say. In adjudication also, no more non-compliance will be in future after the adjudicating authority has been order has been complied. In compounding also, once the compounding order has been complied, there will not be non-compliances. Now last part, again, till now, am I clear? Am I clear till now? Am I clear till now?
Okay, thank you, Sanjeev ji, Pooja ji, thank you so much. Not dealing with MCA show cause notices. See, this is something which cannot be restricted by my view. I will be telling you that how I process, how I process the show cause notice. So, firstly, the interpretation of law as per you should be there, because see, 441 may be having different view, which we have recently observed in the earlier slides. So, interpretation of law can be different of different people. It might be the possibility you may have a different view in comparison to the department's view. Recently, what has happened that department have issued show cause notices for non-compliance under 135, that is CSR, to all the companies, even if the company is not having applicability. So, so that is an interpretation issue. You can challenge that thing. So that is what interpretation of law. Limitation Act, you have to check for the Limitation Act, though this is a very, again, unresearched area, you can say. And Limitation Act, whether ROC can take up any matter. Suppose you have done some non-compliance in 2000 and today that ROC can take it or not. So you have to research on that thing also. That can be also one of the ground. A request for representation, I have already told you that always request for oral representation. Fourth, deny the offense. What I have observed that people are replying with a lot of facts in their hand and they're writing all things, but they are not anywhere writing that, yes, no offense has been done by me. They are not writing it. I have seen that thing also. And next is alternate option. Suppose you have filed entity 7 for 2020-21 and you attached some invitation card in spite of list of shareholder. Now in the next year, show cause notice got received from the side of the department to you, and you realize that was a mistake. You have attached the wrong PDF file. So try to give an alternate option to the authority that now in the upcoming year, in this year, when I will be filing MDT 7, I will be filing the list of shareholder for the earlier year also. So that was not the intent of mine to hide that thing. I will be providing that thing. There is no difficulty. But try to give the option. Why? Because when you give an alternate option to the department, there is a strengthening that will strengthen your negotiable power with the department. Now there are two forms in Companies Act. One is STP, that is straight through process. Nobody checks it. When you file it, you get the approval. Second is the approval mode, that is diatorial removal of director. Okay, so if it is STP, if you are challenging that thing, why they have scrutinized that particular form after 5 years, 6 years, so that will be a little tricky on your part. But suppose you have filed diatorial for removal of director, and that has been approved by the authority after giving the resubmission and getting satisfied reply from your side, then you can challenge, yes, this approval has been given once you are satisfied. Now today you are challenging your own approval. That can be one of the ground. I'm not sure how much it is going to help you, but that can be a very good ground for you. Now, officer in default. Generally, what I have observed that ROC or the department is issuing notice to all the directors which are there in the master data, and director also replying sorry. So that should not be the way. Always see for the particular year of non-compliances whether that director to whom the notice has been received, whether he was the officer in default or not. In this scenario, the other thing can be that sometimes the company passes the resolution. That can be an advice for you people to give an advice to your client. If the company passes a resolution at the starting of the year that for the compliances of the Companies Act or any other law, the Mr. X, director of the company, will be responsible. If this resolution has been passed, so he will be particularly the officer in default. So you can give that reply. Okay, so this is all from my side. Hope I was able to convey you my views correctly and efficiently. If there is any query, I would be happy to discuss that thing. Yes, please. Yes, Ajay ji, please.
Sir, another question is, does the act or rules provide how the show cause notice can be served on company or directors or KMPs, either physical or in electronic mode? Because question is,
that can be provided anyway.
See, this question has arisen because in tax laws, the courts have this given a judgment that even communication through WhatsApp is can also be considered service of notice.
No, that picture has not been there under Companies Act till now, in my view, in my knowledge. So presently they can issue notice through electronic mode also or physical mode also. I have handled cases relating to both the ways. Yes, there is no bar and there is no specific mention under 454, but Act allows them to do so. They can issue physically or you can say electronically also.
Okay. Another question is a company that was incorporated around 1.5 years back. They didn't made any compliance after the incorporation, like filing of INC 20A or any say opening of bank account or subscription money. Later on, the company was strike out by the ROC, and the director, the promoters got the notice that company has been striked off. Now, is there any default which they can go for compounding, or department will initiate any action suo moto on the directors?
See, this is a very specific case which is going nowadays. I think you are having your specific case because once the company has been striked off, firstly, that company cannot move for compounding or adjudication until or unless it has not been revived. Because otherwise, also, if it will get the compounding order or adjudicating order. Firstly, for compounding, they will not be able to file GNL1 because this company has been striked out. Technically, they cannot file GNL1. Suppose anyhow the adjudication has happened, they will not be able to comply with the adjudicating order because they will not be able to file the penalty imposed on them. So practically, strike of company cannot do so. But simultaneously, whether ROC can impose penalty on you, ROC may issue notices for the non-compliances, but till now they are not taking any action. As per my understanding and in experience, they have not issued any notice to the strike of company's director and KM. As per my understanding, they are also they have just striked off the company and they have kept it separate. So that is
okay, because it has happened in many cases during the companies incorporated during the COVID periods, and somehow few people could not continue, and then this
I know.
Thank you.
Yes, thank you. Any other query, please? Okay, in the chat box, Pooja ji, thank you so much, Pooja ji, for being attentive during the session. And I think there is no further query, right? So I will just say thank you to you people. And I would request you all to be in touch because we are limited people, only 14 to 20. So it will be great to be in touch. And these are my contact details. In case you need any sort of help, I will always be available. Thank you so much.
Thank you, Santosh ji, for wonderful interactive session. And I hope everyone have enjoyed today's session.
Thank you. I think Sangeeta is saying.
Yes, madam. Yes, madam.
मैं एक चीज कह रही हूँ कि ये इंडिपेंडेंट डायरेक्टर्स के जो कंप्लायंसेस के लिए रिस्पांसिबिलिटी है, कैन वी हैव समथिंग स्पेशली ऑन दैट?
संतोष जी
नहीं आपसे पूछ रही है वो एक्चुअली शी वांट यू टू अरेंज अ सेशन ऑन इंडिपेंडेंट डायरेक्टर. एम आई करेक्ट संगीता जी?
हाँ सर, वो तो है ही. प्लस अगर आप भी हमें कुछ मोटा सा ब्रीफ कर दें.
नहीं, आज के लिए इतना काफी है. कंपाउंडिंग एजुकेशन
इस पे प्लान करते हैं. ये भी ना एक लंबा टॉपिक है.
डेफिनेटली हाँ, इंडिपेंडेंट डायरेक्टर कैन नॉट बी समड अप इन 5-10 minutes. So definitely it's a very lengthy topic. So I will be happy to.
सर आजकल क्या हो रहा है कि जो ये ऑफिसर है ना, मतलब एमसीए तो सबको ही नोटिस दे देता है, ठीक है, और जो कंपनी भी है जिसकी प्रॉपर कंपनी रन हो रही है, व्हाई दे मेक इंडिपेंडेंट डायरेक्टर टू डू ऑल द कंप्लायंसेस, मतलब हर जगह पे. तो आई जस्ट वांट टू अंडरस्टैंड कि हु शुड बी द करेक्ट पर्सन टू बी मेड because I am not doing the day-to-day work of theirs.
I
And they
know.
want
So
to
we
put
will
everything on us.
discuss this thing separately. No worries. You are having my
हम
contact
उस पे
details. We
प्लान
will
करते हैं,
discuss. So
अप्रैल में प्लान करते हैं एक सेशन इस पे सेपरेट इंडिपेंडेंट डायरेक्टर्स के रूल्स क्या हैं, रिक्वायरमेंट्स क्या हैं,
we can do it. Yes,
और
yes.
वुमेन्स डायरेक्टर्स की भी क्लब कर लेंगे इस पे, तो एक सेपरेट सेशन प्लान करते हैं.
Rather, it can be directors and directors' duties and responsibilities.
Right,
This
right,
can be a
right.
very great topic, है ना?
Yeah.
Thank you, and Santosh ji, thank you so much for your wonderful, insightful session, and I
Thank you
hope
so
everyone
much.
have enjoyed, and we
Thank you
will
so much.
share the recording to all other participants. So, कुछ कह रहे थे संतोष जी आप?
हाँ, अजय जी, are you from उत्तम नगर?
हाँ जी संतोष जी.
अच्छा, वो मतलब हम लोग टच में हैं already.
Yeah,
Good
we
to
are
see you,
in
sir.
touch.
Good to see you. Good to see you. देखो, see my memory. I can recognize you by name only.
That's you can say that's a specialty of professionals.
Thank you.
नाम ही काफी है.
नाम ही काफी है.
स्पेशली लीडर लाइक संतोष जी जो NIRC में इलेक्टेड मेंबर है, so definitely sir, संतोष जी great.
Thank you. Thank you, sir.
So
so
thank you
much.
Ajay ji, thank you, and thank you to all one, and
Thank you
definitely
everyone.
and जो हमारा एक सेशन रह गया, we will plan it in the next week,
Right.
and we will inform to you each and everyone. Thank you Santosh ji, and thank you all
Thank you.
participants.
Thank you.
Thank you
Thank you
so much.
everyone. Thanks.
Thank you.